Hey guys, how's everybody doing? Oh, my mic is giving me an error. Let's see. I don't see the calling me. There we go. Now I see my audio's working. All right, well, hello everybody. I see everybody's here early for the party. Created by EJF is in the building. Perfect peace with the well wishes for everybody. You guys might remember hearing about this case over the last year or so. It's for good reason. It's, I think, a widely talked about case. And there's been some new activity because after SCOTUS unanimously decided the underlying court needs to get it together and issue some clarifying decisions on this one, they got rid of the decision, remanded it back to the 11th Circuit Court of Appeals, and oral arguments in that case happened this morning. So we're going to do a quick rewind on like the history of what happened and the timeline of the process of litigation in this matter. And then we're going to watch those oral arguments that took place this morning. If you want to watch the Supreme Court, the SCOTUS arguments, they are linked in the description, but we're not going to watch those today. So, quick background here. This is coming from the Institute for Justice, and they take a lot of cases like this on pro bono. Here we have Curtrina Martin and her family members suing the United States, and I believe they sued one of the FBI agents because there was a wrongful raid on their house. They get this warrant, the FBI gets a warrant. They're permitted to go do this search and possible arrest at a given address. The FBI agent showing up to the scene and I guess running the shots used his GPS, and when the GPS told him he arrived at the location, he just went to one of the homes without verifying if it matched the same house number, property number to the one on the warrant. He just trusted the GPS. So they raid the wrong home, and the family initiated a lawsuit against it, seeking remedies for the damages that this caused. So quick background here, because I'm sure this does a much better job than I will. We have in June 2025, the Supreme Court ruled that the family's fight for justice can continue and refused to create a new immunity for federal misconduct. So before the sun came up one morning, Trina Martin, her son Gabe Watson, and her boyfriend Toy Cliatt were startled awake in their home by the sound of a flashbang grenade exploding. Can you imagine? Trina's instinct was to run to her 7-year-old's bedroom. So 7 years old at the time. Just crazy. Fearing for her life, but Toy, fearing for her life, grabbed her and pulled her into their walk-in closet. As Toy was reaching for a shotgun to protect his home, an FBI agent opened the door and snatched Toy. Toy was handcuffed and thrown on the floor. Agents angrily shouted questions at Toy, but when he told them his address, the room went silent. The SWAT team realized they were in the wrong house. Agents quickly left and raided the target house. After that, an agent returned, apologized, and left a business card for his supervisor. But the FBI provided no help to Trina, Gabe, and Toy as they struggled to live, work, and go to school with the trauma of the raid hanging over them. So Trina, Gabe, and Toy filed a lawsuit against the government under the Federal Tort Claims Act, FTCA. Now, this is going to be pretty important. This is kind of going to be the crux of the argument of what we're going to hear argued today. Congress passed the FTCA 80 years ago to provide everyday Americans with a remedy for harms caused by federal employees. Congress extended the FTCA further in 1974 to ensure that it covered mistaken federal police raids, like the one committed against Trina, Gabe, and Toy. So here, and this is coming from the Institute for Justice, who they're obviously on the side of the appellant, or the petitioner, the plaintiff in this case. So, I mean, technically they're going to write these laws support what they're arguing. My personal opinion, I'm not a lawyer, but I seem to agree. That seems to be what the intent of this was. Congress wanted people to be able to get some type of remedy when they were the subject of a mistaken police raid. And if that's the intent, if there's some type of loophole that's preventing that from being what can happen, if there's an obstacle in that pathway, the courts should take that into account and want to get rid of that obstacle. So just wanted to clarify, we are reading from someone who is, representing the Martins in this case, but I find it to be agreeable, their position. But in the decades since, the courts have made a muddled mess out of what should be a straightforward law. Whether the FTCA actually provides the remedy Congress intended depends not on the language of the statute, but on where in the country the language is being read. Unfortunately, for Trina, Gabe, and Toy, the interpretation came from the 11th U.S. Circuit Court of Appeals, which applies broad immunities to the FTCA. Here, because the court inexplicably concluded that FBI agents, so they're talking about the 11th Circuit when they say this, they inexplicably concluded that FBI agents have the discretionary authority. They have the choice. They have decision-making in the moment. They have the discretionary authority to raid the wrong house, and thus sovereign immunity barred the claims. According to the court, Trina, Gabe, and Toy had no remedy for the raid because the almost deadly mistakes that led the FBI to kick in an innocent family's door were arguably characterized as a policy decision. So after that, we appeal it up to SCOTUS, right? After that appeal, again, Institute for Justice helped with this appeal. They do the pro bono work. The Supreme Court agreed to hear Trina, Gabe, and Toy's case and unanimously held that the case may proceed. The Supreme Court sent the case back to the 11th Circuit, urging a, quote, careful re-examination of the case. On remand, Institute for Justice and the Martin family will have the opportunity to explain why claims like theirs do not fall into any of the FTCA's exceptions. So no discretionary authority that then allows for sovereign immunity, barring claims like this. And this is the argument we're going to hear in a few seconds. Institute for Justice insists that the courts respect Congress's decision to provide a remedy for federal harms. The courts cannot create immunity where Congress has waived it. So this page has a ton of resources if you want to go read any of the briefs. Check out the oral arguments. The oral arguments I linked is a different resource. It has these really, really cool, this channel Supreme Court oral argument transcripts. They break the transcript down based on who's speaking, which I think is very helpful. So that's linked in my description. But for all other resources, I recommend checking out what Institute for Justice has put together on this case. Real quick, we're going to get familiar with Patrick Giacomo. He's going to be who we hear argue on behalf of the Martins today. He's also the one that argued in front of SCOTUS. But I think this just adds some, I don't know, some color to what we're talking about. We get to see the house. We're going to see the family. It just brings a voice to life.
We're heading back to the U.S. Supreme Court.
This is old.
This time to fight for an innocent family who suffered when an FBI SWAT team raided their home by mistake. Trina Martin, her partner Toy, and her then 7-year-old son were asleep in their suburban Atlanta home when exploding flashbang grenades startled them awake. FBI agents rushed in and held the family at gunpoint. Toy was handcuffed and thrown to the floor. But agents soon realized they had the wrong house on the wrong street. So they left to go raid the right house. The Martin family was left, on the other hand, to pick up the pieces with no help from the FBI. But when law enforcement, including the FBI, raids the wrong house, it must be held responsible. Inexplicably, a lower court let the government off the hook, even though Congress passed a law to ensure that Americans can sue the federal government for wrong house police raids. We're hopeful that the Supreme Court will restore the protection Congress provided for the Martin family and all Americans who have the right to feel safe in their own homes.
So there we go. I just, as we go over to these oral arguments, we're just going to be sitting on a screen. So just wanted you guys to have like a bit of a visual of the who's who. So this was about 41 minutes this argument took. It's going to be a 3-panel of judges. And as I'm seeing here in the chat, M40A5 says, just finished Andrea's last video and you have perfect timing. Andrea Burkhart just did a video on, the issues with the search warrant and affidavit underlying the raid on Afroman's home. Now, a bit of a different framework, right? We're not dealing with feds. We're not dealing with the FBI doing a raid. And it's a bit of a different issue. It's not, hey, the search warrant itself was invalid. It's these knuckleheads go out there, rely on a GPS, and go to a totally different property and don't verify if it's the same one that's permissed in the warrant. So a bit of a different context, but the overarching question of immunity, I think, applies. And with the Afroman trial, sure, it was a civil trial where the officers were suing in their individual capacities, but I think conceptually, a lot of us, myself included, would characterize that as cops suing somebody for speaking out against them after a raid on his home. So, differences but similarities. So I'm going to drop a link in the chat to that, and it's also in the Creator Friends playlist if you guys missed Andrea Burkhart's breakdown on the search warrant in the Afroman case. Now let's get into this one here. Let's hear Giacomo argue.
Our next case is number 23-10062, Curtrina Martin et al. Versus the United States and Lawrence Guerra. Is it Giacomo or Giacomo?
It's Giacomo, Your Honor.
Neither one. Okay.
I want to let you know this is the only reason I knew how to pronounce his name. I would have said one of the other two pronunciations before I said Giacomo.
Giacomo, welcome. Whenever you're ready.
Thank you. Good morning, and may it please the court.
Ron.
Patrick Giacomo of the Institute for Justice on behalf of the plaintiffs. In 2017, an FBI SWAT team raided the wrong house, traumatizing the innocent family inside. After a panel of this court dismissed plaintiffs' FTCA claims, the Supreme Court revived them all, and then remanded to this court to carefully re-examine this case in the first instance. Guiding the analysis on remand, the court also observed that Georgia law would permit a homeowner to sue a private person for damages if that person intentionally or negligently raided his house and assaulted him. It then asked this court to consider two things. First, whether the discretionary function exception bars either plaintiff's negligence or intentional tort claims. And second, if so, whether a private individual under like circumstances would be entitled to claim a defense from Section 2674, which covers judicial immunity, legislative immunity, or any other defenses to which the United States is entitled. The answer to both questions is no. First, the discretionary function exception is no bar to these claims for the simple fact that the actions here were neither discretionary nor a function. The actions were not discretionary because the SWAT team was purportedly following the order of a court and executing a warrant for one house, but instead they mistakenly went to another. There's no room for discretion in deciding where to execute the warrant. And second, this was not a function because raiding the wrong house is not a permissible exercise of policy judgment. It's not an exercise of policy judgment in any way, nor is it grounded in policy at all. In fact,
all right, I just think that this is a phenomenal argument because, again, the decision that the 11th Circuit handed down was vacated. It's gone after SCOTUS said, all of us agree here up at SCOTUS that you got to redo this one, 11th Circuit, get it right. Something's not right here. And they had argued, they were like, oh, we agree with the state's argument that it was just discretionary and they're entitled to the sovereign immunity as such. But Giacomo comes in there and he's like, if the property address is signed off, a judge signs off on this warrant, then there is no discretion. The permission is ordered and constrained by that search warrant. And just like that, an argument that the discretion element is gone. And I just think it's a great argument.
as the government said to the US Supreme Court, it's the policy of the United States to raid the correct house. So even if that were a policy, it was violated here.
But you don't ask whether well, I have so many things to say about this case, but because it's hard, because it's very hard.
Yes.
So let me start at first principles.
Please.
You've asked us to basically re-examine a lot of our discretionary function jurisprudence in light of what the Supreme Court said in this very case just a year ago.
Well, Your Honor, I would say the Supreme Court has directed this court, and I'm asking the court to...
I know, but the Supreme Court is not the 11th Circuit.
Correct.
And the Supreme Court has the freedom to re-examine its precedents.
Yes.
Whenever it deems it appropriate to do so. We are a humble 3-judge panel, and we do not have the authority to, I mean, in certain circumstances, we can find, as you say, with a couple of cases that have been abrogated.
Yes.
But we don't have the general authority to just disregard prior 11th Circuit precedent that we think is wrong.
Correct.
And I've done the research and counted personally. We have over 60 published cases since 1999 on the discretionary function exception, and they're all over the place.
Mm-hmm.
Some of them read it narrowly, some of them read them broadly. Some of them have great language for you, some of them have great language for the government. Some you can harmonize, some you can't harmonize. These are all my views. I'm not speaking for my colleagues. So it's really hard to do first principles when we are trying to make our way through a landscape that's just dotted with decisions.
Believe me, Your Honor, no one's more sympathetic to this confused landscape than I am. As someone who practices outside of the 11th Circuit as well, I can tell you that that's not an outlier position. Every circuit has been all over the place on what this exception means because the Supreme Court hasn't really guided the analysis since the Gaubert decision in 1991. But as to this case, I would say two things. First is that it very well may be that to, in a fulsome way, address the questions that the Supreme Court identified, this court will need to go en banc. But second, I would be happy to talk through the court or talk with the court through some of the potential obstacles of circuit precedent here. And so I'd like to begin doing that by pointing out that as the Supreme Court identified, there are issues on three separate matters that could implicate circuit splits or previous circuit precedent here. So first is whether the discretionary function exception applies to careless mistakes, which this case obviously indicates there's been carelessness. Here we have the FBI basically claiming they fat fingered the GPS. They showed up at the house. They didn't look at the street sign. They didn't look at the house number, and they went in anyhow. This circuit has not weighed in on the carelessness split, which is drastically in favor, or which is equally divided between 3 and 3 on whether the discretionary function exception covers careless acts. It should not, because the language of the exception itself says that the act has to be based on a discretionary function. The second issue, though, and I think that this next best route for this court would be
but you don't, well, so this is a sort of foundational question. I'll ask the government the same thing if I remember. You look at the function, but not whether the function was carried out appropriately or negligently, right? To figure out whether the discretionary function exception applies.
Well, Your Honor,
I mean, if you have the highest level policy-making decision, one that you really can't contest is at the highest levels of government decision-making, right? The government is faced with, a forest fire that is going to engulf 2 communities, but only has the resources to save one. They decide we're going to try to save this community because there are more people there and get the other people out of the second, but the houses in the second are just going to be lost. We don't have enough resources or manpower to do that.
That's correct.
Right. But you don't look to see whether or not that decision was implemented at that level, negligently or not, right?
That's correct. And if I might, Your Honor, that's actually a great hypothetical because we have a case from the U.S. Supreme Court essentially evolving that. And the case is called Rainier. It's from the 1950s. And there were lawsuits against forest management officers who had taken on the act of fighting a fire and then did it negligently. And there the Supreme Court said the discretionary function exception would not apply. And the distinction that the court has consistently drawn from Dallahite through Indian Towing through Rainier all the way up to Gaubert.
Did Rainier actually address the discretionary function exception?
Yes, it did, Your Honor.
You're sure about that? I mean, they have the language you just said, but I'm not sure that it addressed the
Shout out
exception.
Chuck for the
Go
5
ahead.
gifted
Okay,
subs.
so in Indian Towing
Thank you,
then, which also addressed the discretionary function exception, we have a situation where the court is explaining the Coast Guard can decide whether, based on policies for maritime management or other things, it wants to keep up certain lighthouses. But once it does decide to keep up a lighthouse, it has an obligation to do that non-negligently. And so the government couldn't get off the hook in that case. It couldn't get off the hook in Rainier. And this is the same sort of logic that would apply to a situation that would come down through the hypothetical Your Honor identified.
Yeah, I don't think Rainier addressed the exception.
Well, I may be mistaken.
I think it had the language you said, which suggested the way it would, but I don't think the exception was asserted by the government in that case.
Okay, well, then I apologize if I'm mistaken about that, Your Honor. But Indian Towing is another great analogous case. It's the same sort of situation you described, except instead of fighting a fire, we're deciding whether to administer lighthouse upkeep, or the Eastern Airlines case, which is, the Supreme Court's essentially just affirming a DC court decision with the same thing there, where they're saying the FAA, its policymaking on how to do air traffic control, that's something that cannot be collaterally attacked because of the discretionary function exception. But the decisions of air traffic controllers and whether they're negligent is something you can bring a claim for. So this is not, we're not trotting any new ground here. This distinction is discussed in Dallahide as well, where the court is saying, here all the negligence claims are essentially claims that are meant to attack the policy of how this fertilizer would be created and then shipped to Europe. And what the court says there is there's no allegation here that there was an individual act of negligence. For instance, something like a dock worker throwing a cigarette into the hold of one of these ships that exploded and killed 600 people. And so I think that's the way that the court should address these things, because again, the sort of lodestar for all of this from Dallahide on has been the purpose of this exception is to prevent the use of tort claims as a way to collaterally attack policymaking. And so that can be a difficult question in certain areas. It's not a difficult question in this case. In fact, if we were in the case like Rainier or in Indian towing, I would give you a hypothetical and say, for instance, if a SWAT team raided the wrong house because it failed to check the address, that would be an easy case that we would know this is not a discretionary function. And so now it's strange to find ourselves having this important conversation in a case where the application should be very clear. Because here there was no overarching policy. That was the government's position the entire way up on the appeal. It got to the Supreme Court and then said the policy was to raid the right house, which of course was violated. And now we're back here and the government is scrambling. So it points to a single PowerPoint slide that effectively told the officers, do a good job when you execute these.
Wait, what? They came prepared with one PowerPoint slide. You know the government and their PowerPoint slides. They love their presentation.
Position the entire way up on the appeal. It got to the Supreme Court and then said the policy was to raid the right house, which of course was violated. And now we're back here and the government is scrambling. So it points to a single PowerPoint slide that effectively told the officers, do a good job when you execute these warrants. And that's not policy for purpose of the discretionary function exception. But even if it were, the SWAT team failed in satisfying that policy. It went against that directive. And so this is an interesting case because it's probably one of the very few that can fail on the first step of Gaubert.
What do you do with the language in some Supreme Court decisions and some of our decisions which say that the exception applies also at an operational level?
Yeah, so I think what Gaubert said was that was a formally dispositive distinction, of course, in Dallahide, or at least it had been interpreted that way. And they said that's no longer going to be dispositive. And what I would do with that is look at what Justice Scalia says in his concurrence in that case, which is to say, sure, that's not dispositive, but it's got to be relevant to our analysis because we're looking at the kind of conduct that, and deciding whether that is something that would be grounded in policy. So it may be that there are these uniquely Byzantine and overarching regulatory schemes like in Gaubert, where you have federal savings and loan that's very highly regulated, and you have a regulation that specifically says this person is basically acting as a conduit of policy from the highest levels of the agency. But that doesn't mean that every operational act, certainly not the ones in this case, should be given that treatment. And we know that because Gaubert itself said, this, of course, wouldn't apply to things like driving. Even if it was a banking regulator driving to the bank, that's not a discretionary function. And that's, as Justice Sotomayor points out in her concurrence, a huge problem for the application of this doctrine to this case. I'd also...
What about the Mesa case?
Thank you, Your Honor. I was just about to raise the Mesa case.
Okay.
So I have several things to say about Mesa. One, I think it's distinguishable because it's an arrest warrant, not a search warrant, and they arrested someone with the same name. But I think more importantly,
But this case had both warrants.
It did, but they didn't arrest anyone with the right name in my client's house. But I think the more important reasoning for why Mesa is abrogated as to this point is that it was predicated on the premise that executing a warrant is discretionary. In fact, the district court there said the plaintiff's claim that executing a warrant is ministerial, that's plainly wrong. But in Utah versus Strieff, the United States Supreme Court very clearly said that executing a warrant is in fact a ministerial task. And so Mesa has been abrogated. This is even under the very strict rules of binding circuit precedent. This is a situation where the premise of that point has been completely eviscerated after the Strieff decision because now we know that this is in fact a ministerial task. I'll just say on the point of shivers, I think that's an issue that would have to go en banc. That's a 2-to-1 decision where both my friend and I agree that at least the holding that no constitutional exception applies is wrong. And so I would urge the court to consider that, but I would like to reserve the remainder of my time.
All right, thank you very much.
Thank you.
All right, time for the government's arguments. Yeah, and that was Patrick Giacomo that we heard
Mr.
arguing.
Ross.
And this is who, Mr. Ross? Russ?
Mr. Ross.
Ross.
Good morning, and may it please the court. Aaron Ross on behalf of the United States and FBI Special Agent Lawrence Guerra. The district court correctly held that the discretionary function exception covered each of plaintiffs' FTCA claims. That holding reflects a straightforward application of the Supreme Court's Gaubert decision and this court's precedent.
All right, let's talk about how to define the exception at various levels. Do you agree that there are some, we'll use operational for now, that there are some operational decisions on the ground that are not covered by the discretionary function exception?
Yes, Your Honor, we would have to apply the Gaubert two-part test to determine whether it's whether the conduct in question
give me an example of one operational decision on the ground involving choice by a government employee that's not covered by the discretionary function exception in your view.
So your premise is the first prong's been satisfied and we're now looking to the second prong. Is that correct? The first prong asks to whether there's an element of judgment or choice. That may not be.
Yes, there's a judgment. Yes,
Okay.
there's a judgment of, there's an element of choice in almost everything that human beings do. Human beings are seldom automatons.
You could have a law enforcement action that does violate a policy where a policy specifically mandates a specific course of action. So you could fail the discretionary function exception test at policy level prong 1. You could also on an operational action.
Yes, I agree. I agree with you. So yes,
You could-
level 1, prong 1 is satisfied.
Right.
So tell me what exercise of choice operationally by a government employee would not be covered by the exception. Give me an example.
Right. I came across a case where DEA agents were doing a narcotics bust. I think this case was called Patel out of California. And after they ran out of non-flammable ammunition, they used flammable projectiles, which ended up burning down the house and the suspect inside.
Damn.
And what the court said is, this is not susceptible to policy analysis because the point of the DEA is to recover drugs, make arrests, not to burn down the entire house and the evidence inside. And so that was a situation where it satisfied prong 1, but didn't satisfy prong 2.
How's that different than here?
In here, we have many decisions that are susceptible to policy analysis, and we know that from Mesa.
What is policy based about going to the wrong house?
Well, we look at the decisions that the agents are making in conduct of identifying, locating the proper house, and what Agent Garrett testified here, and
That's not policy based.
it's grounded in policy considerations.
No, it's not. You're supposed to, you can only execute a warrant, search warrant or arrest warrant at the place described in the warrant. There's no level of discretion involved there. A police officer who has a search warrant for house A can't decide he's going to execute it on house C.
Under Mesa, the relevant conduct is the decisions as to how to locate the target of a warrant. And the warrant itself doesn't mandate specific course of action on how to locate the target of a warrant. It just identifies an address. And so under Gaubert, it satisfies prong 1 because there are numerous decisions an agent has to make in identifying and locating the target of a warrant.
All right, let me give you a crazy hypothetical. Okay, not this case. Police officers, FBI agents have a warrant, search or arrest or both, for house A in neighborhood 1. They're pressed for time, so they say, let's go into the very first house we see in the neighborhood. Maybe we'll get lucky and arrest a suspect there. It'll save us some time. Is that covered by the exception?
They're not attempting to execute a warrant in the sense that they're trying to locate a house. They're just going into a house that they see.
But to execute the arrest warrant,
I don't think that would be covered, because just making no effort to identify the proper house and just picking houses.
the line can't be making no effort and making a negligent effort. That
Well,
can't be the dividing line.
I think the question is whether they're performing their law enforcement function. I think when
They are
just
performing a
going-
law enforcement function. They're just doing it very badly.
well, I understand your point, Your Honor. I think
Well,
it's
tell me how
I think when
be making no effort and making a negligent effort. That
Well,
can't be the dividing line.
I think the question is whether they're performing their law enforcement function. I think when
They are performing a
going-
law enforcement function. They're just doing it very badly.
well, I understand your point, Your Honor. I think
Well,
it's
tell me how that case is different than this one. From a policy-making perspective, it involves choice. It involves identifying the place to go to, the reason you're going to go there, and you make a colossal mistake and go into the wrong place.
I
What's
think-
the difference between my hypothetical and this case?
I think in your hypothetical, it may be that under prong 2, they're not making decisions as to how to locate and identify the target of a warrant that would be grounded in policy considerations. They may be, if you have a situation where it's extremely dangerous like this one, where you know that the suspect is violent, surveillance conscious. Agent Garrett testified to having wiretap recordings showing that these people were looking out the windows and watching drive-by. So Agent Garrett has to make decisions going in the darkness.
Like, dang, I can't even look out my windows without it, justifying a negligent execution of a search warrant.
Dimming his lights, not spending a lot of time driving by. You could have those considerations. I don't think the DFE is categorically inapplicable to the situation that you described. I would just need to know more facts to know whether it did apply to that situation.
I just don't see that you've provided a workable line in your brief,
Well,
because everyone agrees that at some operational level, decisions on the ground, though they involve choice, are not covered by the exception.
well,
And I don't know what that workable line is.
Well, I think we can look at the record here and Mesa, because what Mesa is talking about are the decisions weighing the urgency of the apprehension versus protecting public safety, preserving evidence. In this case, we know from the SWAT addendum that this was FBI was trying to achieve simultaneous execution of multiple warrants across the city to ensure surprise and to protect the agents and the public safety. So there are actual considerations in this case that are grounded in policy, and that's serving the FBI's mission of enforcing the laws, stopping gang activity.
But that may
protecting
go
citizens.
to how you execute the warrant, not where you execute the warrant. So for example, if the agents here decided that the suspect was extremely dangerous and they had to proceed by driving to a location where they were going to meet under cover of darkness without any lights in the car to avoid detection, and they crashed into somebody on the way there, I can see how that could be a decision grounded in policy determinations. But that's about how you execute a warrant, not where you execute a warrant. As to the where, there's no discretion. You can't go anywhere else except the place identified in the warrant.
Well, and my response to that, Your Honor, is that's not what the discretionary function exception is looking at. The challenge conduct is the conduct in a general sense, or the nature of the conduct. And what Mesa says is the nature of the conduct in this situation are the decisions as to how to locate and identify.
If the FBI had a written policy with a checklist of things that the agents had to do to verify the place identified in the warrant, and the agents deviated from it, would this come under the exception?
No, it would fail under prong 1. If there's a policy that mandates a specific course of action for the employees to follow and they don't follow it, then the prong 1 is not satisfied.
And the FBI had no policy in place in this time as to how agents were supposed to identify the right place?
No, Your Honor, they did not.
That's a remarkable statement.
Well, it affords agents discretion because each situation is different and it's case by case. And
No, but that's not how to execute the warrant. It's about making sure you're going into the right place. You're telling me that the Bureau, with all of its experience, has no policy on what checklist agents are supposed to go over to make sure that they're going into the right place. There's no policy whatsoever. Agents are just on their own.
There's no policy that defines how an agent should locate and identify the target of a warrant. And that's what the record shows. And in this case, Agent Guerra undertook numerous precautionary efforts, as the district court found and as the prior panel found, including reviewing the operational order and the SWAT addendum, conducting a drive-by,
Yeah,
conducting
but
a site survey.
all of those things meant nothing once he used a personal GPS device that he later threw away.
Well, they did because it explains the context of the mistake, because when he's using the GPS.
What did he say he did with the GPS, by the way? Because the GPS, if you put in the address, at least my experience with a GPS device, will tell you how to get to that address. What did he do with the GPS that led him to the wrong place?
He put in the address, it alerts that he arrives, he looks up, he sees the house with all the markers that he identified before on his site
So the
survey.
GPS took him to the wrong place?
It alerted him when he was in front of the wrong place with the plaintiff.
Wait. He puts the correct address in the GPS device,
Yes.
and the GPS device tells him what? According to him,
You've arrived at your destination.
which is the right place or the wrong place?
Where he was in front of plaintiff's home, not the target home. He looks up.
So the GPS device, according to him, malfunctioned by a block.
300 feet,
A block.
three to four houses, Your Honor.
No.
We're on the same street.
Different, no. A street separated by a cross street. You've got a block, a cross street, a block, and they're on opposite sides. You're minimizing the distance and the spatial reality of the warrant.
Right. The houses are where they're located. The GPS identifies that you've arrived at your destination.
All right, let's take a look quick at, just so you can see kind of like, it's dark body cam. But that way you can see a little bit of what this area looks like, where they're relying on a GPS to say, you've arrived at your destination. And this footage is from the APD, the Atlanta Police Department. They were called in to help with this, even though it was like FBI SWAT team's mission. But they don't have cameras, so let me cue this up. So you can see the houses are close together. It's not the type of thing I would rely on my GPS for having the right one. I'd have to like look at the dot and tell me which property it was saying. And I would also look at the house number, even just to make sure I'm showing up to the correct friend's house. So, but yeah. And then look, you can see the house number right here on the mailbox. So that would have been one thing to cross-reference, cross-check. Oh God. Sorry. Oh yeah, where the types of neighborhoods where they just like put up the same design house one after the other and just change the paint color. But yeah, still. Okay, this guy's just chilling, isn't he? They're looking in the cars. Yeah, they're all so close to the mailbox with the number on it. I would think they realize by this point, though. There we go. So not the most, not a front row seat with that body cam footage, but still, it kind of shows you the neighborhood. And, I think anyone that's used a GPS while driving, I feel like they've probably had that experience where the GPS is like, turn left, but you've already passed where you're supposed to turn. Like, it's not precise. It might not be inaccurate, but it's not precise. And you've got to double check when it's telling you to do something with some discernment for how close, how accurate it is. Anyway, back to the oral arguments. And let me rewind it like 2 lines.
Cross street. You've got a block, a cross street, a block, and they're on opposite sides. You're minimizing the distance and the spatial reality of the warrant.
Right. The houses are where they're located. The GPS identifies that you've arrived at your destination. He's done all this prior preparation. He looks up. It's 3:30 in the morning. He sees all the markers that are unique to the target home at plaintiff's home.
Even though he's gone to the right home before to do a drive-by and check it out. And he's on the other side of the street on a different block.
That's correct, Your Honor. There's a turn. Both houses have a left turn in front. He thought it was the same thing.
Every house has a left turn in front, depending on from where you're approaching.
As the road curves. And I would add that the case agent involved in the case, TFO Thompson, he did 2 hours of surveillance from 200 yards away 2 weeks before. He didn't realize it was not the right house until after they discovered their mistake. These homes.
That doesn't seem policy-based to me. I know we have a lot of cases to wade through, but I don't see how you imbue that decision-making about identifying the house with any sort of policy determination.
He doesn't have the benefit of taking as much time as he wants to go to the mailbox on the other street to see the number from the front of the house, which is on Landau Lane. You can't see the mailbox. It's 5 a.m. They're doing simultaneous execution of warrant.
So we shouldn't try to see the mailbox. This is really I'm so glad we just watched that body cam video. Because now they're arguing about that mailbox.
To go to the mailbox on the other street to see the number from the front of the house, which is on Landau Lane. You can't see the mailbox. It's 5 a.m. They're doing simultaneous execution of warrants. He is considering the safety of the agents involved, the potential that the suspect in the house will see them, alert other.
They literally not have to walk by the mailbox to get into the house.
No, the mailbox, the front door of the house faces Landau Lane. The mailbox is at the end of the driveway on a separate street. And as the district court found, and as plaintiff's counsel conceded at the oral argument, going from the front of the house where they're executing the warrant to the mailbox would have taken time and exposed the officers to threats to their safety. It was reasonable for Agent Guerra and the other agents not to undertake that risk in light of all the other considerations that were being made. And that was the district court's finding. The prior panel agreed with the district court's factual findings. Those were not submitted to the Supreme Court. Supreme Court did not take up the issue of whether discretionary function exception applied in this case. It did not disturb the district court's prior factual findings. We'd ask that the court.
That's not a factual finding.
Well, the factual findings as to all the precautionary measures that.
You mean the historical underlying facts?
That's correct.
I get it.
And so I would look at the factual findings rather than the Supreme Court's characterization of the facts in this case.
Can I ask you a question about the last step in the process, just in case we get to it? And that is the FTCA, assuming the exception doesn't apply, requires a court to determine whether or not a private individual would be held liable under like circumstances under the governing state law. You cite a number of state statutes and state decisions which provide a certain type of immunity for law enforcement officers. Why are those authorities relevant if the FTCA asks you to look at whether a private individual would be held liable?
Yes, Your Honor. To be clear, we're not arguing state immunities. We're not saying state law immunities like Georgia's official immunity doctrine would apply. We're saying that the United States would get the benefit of law enforcement privileges, which are different than immunities. And that would be a situation like an officer is allowed to use reasonable force to defend itself. And this court, and on multiple occasions, we cited the Wimberley case, the Gomez case, and also the Dalrymple case back from 2006. Those are cases in where this court recognized that the private person standard in a law enforcement context requires looking at whether under color of state law, the conduct was privileged. Otherwise,
What's the difference between privilege and immunity?
An immunity is a complete defense to liability. Privilege is just a defense that you can raise that as a local officer could raise, not to bar the claim completely, but to say that my use of force in this situation was justified for this reason, the same as it would be in another case, because otherwise you end up in this absurd situation where a federal law enforcement agent could be making a lawful arrest, but because a private citizen can't do that same conduct, now they're liable, the U.S. is liable under the FTCA. That doesn't.
Where my mind went with this is we heard that Toy didn't know who was breaking into his house. Got his firearm ready, was like hiding on the floor, ready because you don't know what's happening, but you got to be ready for whatever stranger's breaking into your house to come into your room. Self-defense, defense of your family, defense of property. If this had ended in another way, where let's say an officer, one of the FBI agents, goes into the room, the individual that's in the home who has no idea what's going on, and they very reasonably believe that this is just an unjustified breaking and entering, that there is a crime occurring, they're going to defend themselves. The officer sees them sitting there with a gun, assumes it's a suspect who's sitting there about to point a gun at them, shoots first, kills one of the inhabitants of the home. I can see why, hey, that officer relied on, and I hate it. I hate the scenario. But I'm just saying, I think it would be a slightly different analysis than this, where it's just a liability. Let them bring their lawsuit. Let their lawsuit be heard. The whole issue is that this was dismissed by a court. A court granted summary judgment to the government. The Northern District of Georgia Federal District Court granted summary good judgment to the government, which means this case didn't really proceed for enough to seriously consider the litigation. And that's all that this family wants the chance to have. That's why we keep appealing it. Here, though, to argue that no liability because you messed up, like, if Congress wants there to be a remedy for families that have damages to seek some sort of recourse where they can sue for damages and recoup some of whatever happened to them, whatever the actual specific claims are, Congress wants that to be possible. Why are we fighting a liability issue? Because the outcome of this case, I don't imagine that it would have a bearing on, can somebody go and criminally prosecute an officer who was in a home based on a different officer's negligence in verifying the house number, and unfortunately something tragic happened. I feel like maybe the government here is trying to argue that could be a possible chilling effect, something that we don't want to rule on here. And I don't think it's anything that any of the other parties are considering. So to me, it just seems like a desperate attempt by the state to have some type of argument here. Yeah, and it does feel like sometimes this is what it boils down to. Sin City Giggles says only the police can make horrendous mistakes.
Makes sense, and that's what these other circuits have also recognized.
Well, you only get there if the arrest is unlawful.
Well, no.
If the arrest is lawful, you don't have FTCA liability.
Well, under the FTCA, if you took the private person standard literally to not include law enforcement privilege, you could have a lawful arrest. So let's say the agents went to the correct home, handcuffed the plaintiff. You wouldn't think someone would file suit, but a plaintiff could say, a private person can't come into my house and handcuff me. Therefore, the United States should be liable under the FTCA. We're not saying that the United States is immune because this is a uniquely government function. That's what Indian towing says you can't say. We're saying you just need to apply law enforcement privileges so the United States can't be liable in situations where where a private person would never be involved. And so the defense is.
Does that privilege under state law, in your view, have a good faith element or requirement?
So there is, for the false imprisonment claim, there is a good faith defense. And what Georgia law provides is that a law enforcement officer executing a warrant in good faith is not liable for false imprisonment. For the assault and battery claims, the defense is that an officer is entitled to use reasonable force to defend itself or, to secure its premises. Georgia law is clear that a law enforcement officer can, handcuff a suspect and send it to an arrest. And then I would add that the plaintiffs haven't challenged the merits of their non-intentional tort FTCA claims. So we would ask that the court affirm summary judgment both on the alternative holding that plaintiffs' claims fail under state law. And then last, we'd ask the court affirm summary judgment to Agent Guerra on qualified immunity.
So, maybe. I don't feel like he was really asked to weigh in on claims against the individuals. So maybe I'm just misunderstanding what the court was interested in hearing from the state there. I'm of the impression that the state started arguing on behalf of liability attributed to an individual officer rather than a liability claim, sovereign immunity protection for the government as a whole.
All right.
If the court has no further questions, we ask the.
I thought that before you sit down, we still have the initial briefs on the merits here because the Supreme Court vacated the prior panel's decision, which means that decision is no more.
That's correct.
I thought, I don't want you to get into the merits of it, but I thought that in their initial brief to this court, to the initial panel, the plaintiffs also challenged their remaining non-intentional tort claims. I thought they challenged everything on different grounds.
On the discretionary function exception and the supremacy clause analysis, not on the actual elements of the claims. If discretionary function exception didn't apply, for instance.
Okay, I'll have to go back and look at the briefs. I thought that everything had been challenged in the first appeal.
Well, I think it may have said for the reason the district court found, but the district court didn't address the merits of the non-intentional tort claims because they relied on the discretionary function exception. And then for the intentional tort claims, the district court refused to apply the law enforcement privileges that we're advocating for.
Okay. All right. Thank you very much. All right. So let's talk about the last piece of the puzzle if we get there.
Yes.
How do you apply the private person, private individual language of the FTCA with regards to a law enforcement individual who can do some things that a private person can't do when authorized?
Sure. And let me begin, Your Honor, by admitting my mistake. You're correct that Radiator was a unique government function case, not a discretionary function case. So I was wrong about that, and I apologize. The answer to that question is, as Your Honor suggested, actions are still legal or illegal, regardless of whether you're an FBI agent or a private person. And the FTCA is flexible because it's incorporating tort law principles. So in the same way that you'd be able to apply to situations where a security guard stops someone leaving a store and analogize that to law enforcement, or even a case where, similar to this case, you hire a contractor to tear down your garage and they show up at your neighbor's house and tear down that garage. There are a lot of ways to draw these analogies. And as Your Honor pointed out, if they'd gone to the right house and they'd arrested the right person, that would all be legal, and therefore the merits of the underlying torts would not be satisfied. Now, on the related point, my friend is incorrect that the negligence tort merits have been addressed repeatedly at this point. But I think the most important thing for the sake of the procedural history is we're up on a motion for summary judgment that was filed by the government. And as to the negligence claims, their motion for summary judgment brief only asserted the discretionary function exception. It did not assert anything about the merits of the underlying negligence torts. But even if it had, we have again and again and again pointed out that going to the wrong house and raiding it is a negligent act.
Yep.
On the specifics of what you do with something like a state law immunity or privilege, Your Honor is correct. And I would also say that the concept of there being a private person acting under color of state law is a contradiction in terms. The FTCA at two separate places, 1346 and 2674, says that you have to look at the standard of a private person or a private individual under like circumstances. Bringing in immunities and defenses for government officials cannot possibly be squared with that language. But even if it could, in this case, the good faith exception that my friend asserts is one that only applies when someone is arrested under a warrant. There was no warrant here, and that's how they got out of liability for the false arrest claim, is they said, we arrested the wrong people. The warrant as to them was void. If that's true, they can't possibly assert a defense that would apply, even if you get past the official aspect of it, to a situation where they likewise had no warrant to go on. Similarly, with innocent trespasser, they leave out the language of the standard that says that it has to be non-negligent or unintentional, and that there's an exception for dangerous activity, which of course a SWAT raid is, on and on and on. And so I would say, I would like to end by saying we should not ignore the elephant in the room here, which is also the fact that Congress amended the FTCA specifically to allow claims for wrong house raids. And so again, when I said what I said about this being the prototypical example, it actually is. We know that from the context. And so if Congress would go to all that trouble just to make sure there are claims here, courts should not be undoing that by taking small bites away through, applications of the discretionary function step 1 or step 2, notwithstanding the confusion in the case law. So unless the court has other questions, which I'm happy to answer, we would ask that this court hold the discretionary function exception does not apply, and that plaintiffs' claims, all of them, are allowed to proceed to trial.
Right. Stay there for a second because I have a question I'm going to ask Mr. Ross too. There's been a lot of paper since the district court ruled. The Supreme Court has changed, abrogated some of our law. We have to review the district court's order, the initial briefs, the Supreme Court decision, the supplemental briefs on remand, whatever. Do you want a chance to rebrief everything from start to finish in light of the new landscape to eliminate the possibility that the three of us might miss something?
Your Honor, I would be more than happy to provide a more fulsome briefing on this point if the court wants to.
No, it's not on this point. The district court relied on a doctrine that is now gone, right? For some of the claims.
Yes.
Right?
Yes.
Okay. When you initially briefed the case, that law was still governing in this circuit. So you briefed the case in a certain way, right? That doctrine is now gone. So I'm asking you whether you want the opportunity to brief everything again as if we were the initial panel and no briefs had been filed at all, and the Supreme Court's decision had been issued in a different case, and we now knew that our law on the supremacy clause was gone, for example.
The answer, Your Honor, is
Or
yes.
do you think we're okay with what we have?
First let me say I would like the opportunity to rebrief it if the court is going to take up the merits of the negligence claims. And that's because, as I said, the government itself never even asserted on the basis of summary judgment these defenses, or that somehow the negligence-based claims would fail on the merits. So if the court's going to take those up, then yes, I would like the opportunity to rebrief.
Well, no, but here's my confusion. As I understood the procedural history of the case, the prior panel asked the parties what they wanted to do after the Supreme Court's decision. Do you want to remand? Do you want to stay here? Do you want to file supplemental briefs? And as I understand what the parties told the prior panel, the parties didn't want to go back to the district court. They wanted everything or almost everything resolved here. I presume that that's still the case.
Yes, Your Honor.
Okay. All right.
Yeah, and if I may, again, the reason why we at least why plaintiffs said that is because the question of why the negligence claims failed in its entirety was the discretionary function exception. Now, the Supreme Court revived those claims, which I think is a strong indication that it was concerned with the analysis that had been done. But the merits of those claims were never even before the district court because the government did not raise them in its motion. And so what I'm saying is, if we're talking about looking at the merits of the negligence claims, that's something the government never even asked the district court to do as a basis for summary judgment.
Those you don't want us to rule on if the government never moved for summary judgment on them.
I think, well, this court would need to rule on the fact that the discretionary function exception doesn't apply, but it doesn't need to go further than that.
No, I'm talking about the merits of those claims if you get past the discretionary function exception.
Correct. I think the court does not need to rule on those. It can simply point out that the government never made that argument in its disposition, in its request for summary judgment below, so the district court never even passed on it. Now, if the court does want to rule on everything just so it's all in one place, then yes, I would say we would welcome the opportunity to rebrief this as if the entire thing is starting from the government's hypothetical motion for summary judgment that did in fact raise those aspects of the negligence claims.
Okay, thank you.
Thank you.
Mr. Ross, what do you think on this point?
On whether additional briefing.
A briefing to just as if the district court had just ruled, the Supreme Court came out with its decision, but in a different case, and now the plaintiffs are going to file their initial brief with that case as background, and then you're going to respond and they're going to reply.
We can do that, Your Honor. I do not think it's necessary. Again, the Supreme Court did not overrule Galbert. It did not overrule this court's prior discretionary function exception precedent. The district court determined that discretionary function exception applied to each of plaintiff's claims. We did the supplemental briefing that I think addresses the kind of the new landscape in light of the Supreme Court's holding. So I don't believe it's necessary, but we would be happy to do it if the court would like.
Okay, stay tuned. If we want supplemental briefing, we'll let you know in the next week. Okay, thank you both very much.
So there we go. That was today's oral arguments. I think before we wrap this up, for the purposes of, we're not going to watch the SCOTUS arguments from last year. But I was wondering if this was why, I think this might answer my own question about why the government here was arguing and what confused me. But from the Supreme Court's decision, we'll read the whole syllabus thing. But they say here, because the FTC incorporates state law as the liability standard, there's typically no conflict between federal and state law for the Supremacy Clause to resolve. While federal law may sometimes displace state law in FTCA suits where a constitutional text or federal statute supplies controlling liability rules, the 11th Circuit identified no such federal statute or constitutional provision displacing Georgia tort law in this case. So the analysis was lacking something. This is SCOTUS saying that the 11th Circuit, which is where these arguments we just listened to took place today, didn't include this piece, this ingredient in their analysis. They just didn't address it. They identified no such federal statute or constitutional provision displacing Georgia tort law in this case. The court's reliance on in re Nagel is misplaced, as that 19th century decision involved a federal officer's immunity from state criminal prosecution for acts necessary and proper in discharging federal duties, not the federal government's liability under a statute that expressly subjects it to a state tort law on the same terms as private parties. So a few minutes ago when I was like scratching my head trying to figure out why the government was arguing a certain way, I think they were anchored back in this argument that maybe the 11th Circuit embraced previously. Even though the reason we're back in front of the 11th Circuit is not only because SCOTUS said, look, this isn't right, you guys need to do a redo on this, we're vacating your decision, you need to reevaluate all of this. They specifically say that the court's reliance, the 11th Circuit's reliance on this in re Nagel case was misplaced. And I don't know, maybe that was just lost on the messenger. Maybe that was just lost on the guy arguing for the state there. But let's read the syllabus quick to see what SCOTUS summary of their holdings and why they wanted this to go back to the 11th Circuit. So we have On October 18th, this was argued April 29th of 2025 and decided June 12th of 2025. On October 18th, 2017, and this is why, if you remember, the attorney arguing for the state, Mr. Ross, he was like, I would rather use the fact-finding, I'm assuming from the lower court, and not what the Supreme Court said was the recitation of facts. The state didn't want to embrace what the SCOTUS writes here. So on October 18th, 2017, the FBI raided the wrong house in suburban Atlanta. Officers meant to execute search and arrest warrants at a suspected gang hideout at 3741 Landaw Lane, but instead stormed 3756 Denville Trace, a quiet family home occupied by petitioners Hilliard, Cliatt, his partner Curtrina Martin, and her 7-year-old son. A 6-member SWAT team breached the front door, detonated a flashbang grenade, and assaulted the innocent occupants before realizing their mistake. The cause of the error was Special Agent Guerra's reliance on a personal GPS device, combined with the team's failure to notice the street sign for Denville Trace and the house number visible on the mailbox. Left with personal injuries and property damage, petitioners sued the United States under Federal Tort Claims Act, FTCA, and seeking damages resulting from the officers' alleged negligent and intentional actions during the raid. The district court granted summary judgment to the government. The 11th Circuit affirmed, applying a unique approach to FTCA claims. A unique approach. The FTCA waives the federal government's sovereign immunity from suit as to certain torts committed by federal employees acting within the scope of their employment. But that waiver is subject to statutory exceptions, including 2 relevant to a law enforcement misconduct case like this one. The first is the intentional tort exception in Section 2680H, which bars claims against the government for 11 enumerated intentional torts. The second is a discretionary function exception in 2680A, which bars claims against the government that are based on an official's exercise of discretionary functions. Sections 2680H also contains a law enforcement proviso, which countermands. Oh, that's fun. I like that word. It sounds so official. Which countermands the intentional tort exception, allowing suits for 6 specified torts, including assault, battery, false imprisonment, and false arrest, to proceed against the United States when the torts are committed by investigative or law enforcement officers. While most courts hold that the law enforcement proviso applies only to the intentional tort exception, the 11th Circuit's approach is different in 2 key respects. First, the 11th Circuit alone holds that the proviso overrides all exceptions in 2680, including the discretionary function exception, meaning that intentional tort claims covered by the proviso automatically proceed to the merits without further analysis of other applicable 2680 exceptions. Second, to compensate for this plaintiff-friendly approach, the 11th Circuit permits the government to assert a restrictive supremacy clause defense at the liability stage, allowing the government to escape liability when an officer's actions have, quote, some nexus with furthering federal policy, and reasonably comply with the full range of federal law. And they're citing Denson v. U.S. there. Applying its distinctive approach, the 11th Circuit held that the law enforcement proviso protected petitioners' intentional tort claims from both the intentional tort and discretionary function exceptions. The court dismissed petitioners' negligence claims under the discretionary function exception, reasoning that Special Agent Guerra enjoyed discretion in preparing for the warrant execution. On the merits of the remaining intentional tort claims, the court found that the government had a valid supremacy clause defense and granted summary judgment for the United States. So, held. 1. The law enforcement proviso in 2680H overrides only the intentional tort exception in that subsection, and not the discretionary function exception or other exceptions throughout 2680. A. The text and structure of 2680 demonstrate that the law enforcement proviso applies only to the intentional tort exception. The proviso appears within the same subsection and sentence as the intentional tort exception, reflecting the established principle that statutory provisos generally modify only the provisions in which they appear. Section 2680 contains 13 discrete exceptions. Coupled with the lead-in clause, each exception forms a separate sentence and operates as a structurally distinct provision. The proviso addresses the same subject matter as subsection H, intentional torts, while other exceptions cover entirely different topics, like loss of mail, combat injuries, and quarantine impositions. Further, the proviso's definitional sentence expressly limits the definition of investigative or law enforcement of officer to this subsection. So, this proviso that's somehow it seems like the 11th Circuit is just like uniquely interpreting, there's an express limitation in the language of this specific proviso, this subsection H. It says, the definition's limited, investigative or law enforcement officer, limited to this subsection, even though the phrase law enforcement officer appears elsewhere in 2680. Congress's choice to embed the proviso within subsection H rather than place it at the end of the full list of exceptions, as it sometimes does with broadly applicable provisos, further confirms the proviso's limited application to subsection H alone. Let's see. Petitioners' arguments for broader application of the proviso are unpersuasive, so this is where we're not inclined. While the proviso mirrors the language of 2680's lead-in clause by stating that 1346B shall apply rather than shall not apply, this textual similarity does not demonstrate that the proviso applies to all exceptions, which form discrete instructions that may be understood completely without reference to other provisions. The absence of limiting language in the proviso's first sentence does not expand its scope beyond subsection H, as Congress accomplished that limitation through the proviso's placement within the same sentence as the intentional tort exception. Legislative history suggesting Congress intended to address wrong house raids broadly cannot displace what the law's terms clearly direct, as legislative history is not the law, and members of Congress may have had multiple purposes in mind when crafting the proviso. So, 2, the Supremacy Clause does not afford the United States a defense in FTCA suits. The FTCA is the supreme federal law governing the United States tort liability and serves as the exclusive remedy for damages claims arising from federal employees' official conduct. The statute generally makes the government liable under state law on the same terms as a private individual would be liable under the law of the place where the tortious conduct occurred. Because the FTCA incorporates state law as the liability standard, there is typically no conflict between federal and state law for the Supremacy Clause to resolve. While federal law may sometimes displace state law in FTCA suits, where this is getting to that conundrum with the Nagel case, while federal law may sometimes displace state law in FTCA suits where a constitutional text or federal statute supplies controlling liability rules, the 11th Circuit identified no such federal statute or constitutional provision displacing Georgia tort law in this case. The court's reliance on In re Nagel is misplaced, as that 19th century decision involved a federal officer's immunity from state criminal prosecution for acts necessary and proper in discharging federal duties, not the federal government's liability under a statute that expressly subjects it to state tort law on the same terms as private parties. Section 2674 specifies the defenses available to the government, including judicial or legislative immunity and other defenses to which the United States is entitled, but these do not include the 11th Circuit's novel Supremacy Clause defense. So here's what they want the 11th Circuit to be considering, and hopefully that's why we had the questions we had today from the 11th Circuit. On remand, the 11th Circuit should consider whether subsection A's discretionary function exception bars either the plaintiff's negligent or intentional tort claims, undertaking that assessment without reference to the mistaken view that law enforcement proviso applies to subsection A. The court must then ask of any surviving claims whether, under Georgia state law, a private individual under like circumstances would be liable for the acts and omissions the plaintiffs allege, subject to the defenses discussed in section 2674, not a Supremacy Clause defense. They say remaining questions surrounding whether and under what circumstances the discretionary function exception may ever foreclose a suit like this one lie well beyond the 2 questions the court granted cert to address, and their resolution would benefit from the 11th Circuit's careful re-examination of this case in the first instance. So they vacate the underlying decisions and they remand it back to the 11th Circuit. And again, this was a unanimous decision there, with some concurring opinions. So, and if you want to read this full thing, go to, in the description of this video, there is a link to the Institute for Justice, and they've got all the briefs put in there. But yeah, so it seems to me like, and I think the 11th Circuit was kind of hinting at this, and there was some kind of, oh, well, if you do want more briefs, should we pretend to respond to the hypothetical as if the initial defense at the lower court was raised beyond just a negligence and discretion issue? It seems like there might be a different analysis for each of the individual torts that the Martins are seeking relief through. But I don't know how they're going to navigate that with this new briefing, addressing new things that weren't part of the initial request for summary judgment. So I think that'll be interesting to follow. I get the impression like SCOTUS is like, 11th Circuit, why do you want to be so different? Why do you want to be so different like this? Like, why? So Moses says, how do people memorize all these laws? I would imagine it comes with the experience and practice. When it comes to preparing stuff like this, I mean, a lot of the cases have already been mentioned in the briefs. If new stuff is getting introduced, you know, the justices have their own law clerks, like assistants that can look up these different cases. So I don't know if it's necessarily, it's just one person that is aware of all of these cases all of the time, but it's, you know, they've been preparing to argue this for quite some time. They knew to be aware because of their own research, or knew that the opposing party or a lower court had cited a certain case and holding in a decision or motion previously. And so that kind of curates it towards what we're seeing when we hear these oral arguments. So let's see, we've got, yeah, Moses wants to hear that. I think I gotta say, this format is phenomenal. And I'd seen stuff like this before, but I never really realized it was a dedicated channel that uploaded it. It looks like the creative licensing is coming from somewhere else. But when I clicked this link, it didn't open. So I couldn't actually see it. What I'm thinking is they might have copied and pasted this like this and not realized that they broke the link along the way. Although it is longer when I hover over it. But in any case, whoever, whatever is producing these, very cool, very helpful. Even to the point where when someone different is speaking, there's like a different backing color. So you know somebody else is about to speak. Sometimes when it's just closed captions and I'm reading them, I read ahead of what the speaker's saying, and I'm not aware that the speaker is really going to change what looks like mid-sentence according to the captions. And then I hear it and I'm like, oh wait, gotta rewind on that. So this is very cool. This is linked in the description if you want to go check this out. I'm going to drop it in the chat for Moses as well. And I had listened to these last year. Frankly, don't really remember them. But it was a big deal when these arguments were heard last year. Very important argument. And again, it was Giacomo, or is he? He did the arguments for the Martin family at SCOTUS as well. So there we go, you guys. That wraps it up for us getting caught up on what the 11th Circuit heard as oral arguments today. I don't know. It seems like, and I don't know, I don't think it was the same three-person panel, the humble three-person panel, but the request for briefs, it still feels to me like this panel, although they're being told to revisit this issue after SCOTUS ripped it out and said it's all vacated. We all agree that this is gotta be redone. It still seems like this panel wants to be walked into a very narrow lane for them to weigh their decision. And they don't want to just do it all willy-nilly. To speak in layman's terms. Hey, Trikisha. So, but that's it, you guys. In 9 minutes, the interview I did with a juror from the Afro-Man trial will be premiering. So if you want to be able to watch that, it's a premiere, so it's recorded in advance. But the premiere lets you have a chat, so you guys can chat while it's live. That's something they had reached out on the Friday when the verdict, like the Friday of the week of the verdict. And it took us a while. It just took me a while to edit it. But since it was in writing, they're not appearing. I sent them the questions, they wrote out their responses, and I read them verbatim back. I don't change anything. I don't interject with my own commentary. It's just them. They have the floor, and I give the questions. So if you're interested in seeing what a juror from the Afroman trial said, go check that out. I think they were a very, very thoughtful person. And I want to see more people like that on juries. So that will redirect you if you're watching live here. You'll redirect over there for that premiere. And what else do I got? Might go live later tonight to look at the motion for sanctions filed by Fat Joe and his attorneys, Joe Tacopina, Chad Siegel, Jordan Sieve, and more against Tyrone Blackburn and Terrence Dixon. So I'm going to eat something, see how I feel, and maybe do like an 8 o'clock stream tonight. You guys all take care. See you when I see you.